Hello, my name is Monica Sliminski, and I will be talking about involuntary admittance of patients for my health law presentation. In 2013, Justice Edward Bello-Baba dismissed the constitutional challenge to expand civil committal criteria and community treatment orders, which I will refer to as CTOs, added to the Ontario Mental Health Act in 2000. The case I found was about a 59-year-old university-educated former teacher, Ms. Thompson, who was diagnosed with schizophrenia in 1973. From then until the year 2000, she had 13 hospitalizations. Her father was her substitute decision-maker who consented to antipsychotic treatment, stabilization, and discharge. When she would go off the medication, she would deteriorate and be in need of further hospitalization. In December 2000, she was involuntarily admitted because it was stated she was no longer able to care for herself. She was hospitalized for another year with treatment where she improved and was then released into a CTO. When taking drugs prescribed and engaging in the CTO team, her hallucinations and delusions were reduced considerably. Her CTO expired and she refused any further medication. Her treatment team did not renew medication or hospitalization to see if she could remain stable, but sadly it did not work. There were attempts to put her back into a CTO, but there were court challenges. So she returned to her birth country of Jamaica, where she continued antipsychotic treatment. She returned to Canada in April 2007 and was still found incapable and once again admitted. Then once again, in August, she left Canada and has not returned. Her case continued with the Empowerment Council's Systemic Advocates in Addictions and Mental Health. The criteria needed for a person to be admitted involuntarily are: one must be suffering from a mental disorder that could potentially result in harm of oneself, bodily harm to another person, or physical impairment of oneself or another person. The new legislation introduced because of Justice Bello-Baba has given doctors the opportunity to admit someone involuntarily if a person has previously received treatment for a mental disorder that, if not taken, the person causes mental or physical harm to themselves or others, if a person has shown improvement with past treatment, if suffering from the same mental disorder for which the patient has previously received treatment, if the patient is likely to cause serious bodily harm to themselves or others, if the patient is incapable of consenting to personal treatment and needs the consent of the substitute decision maker, and lastly, if they do not meet the criteria to continue as an informal or voluntary patient. The problem that arises with the new legislation is that it is taking away human rights. These patients already have to deal with the burden of having a mental disorder, and involuntarily hospitalizing them takes away their rights and freedom. Most patients with mental disorders also preferred the CTOs to being involuntarily hospitalized because at least some autonomy and liberty were reserved. They have staff that check up on them but still have the freedom to perform most daily tasks without being on constant watch. Now the new law has also implemented that CTOs must enforce with psychiatric treatment with those who meet the extended involuntary hospitalization standards. With these new laws, the Empowerment Council finds that many sections in the Canadian Charter of Rights and Freedom have been breached. Section 9, which states everyone has the right not to be arbitrarily detained or imprisoned. In Ms. Thompson's case, this section is overstepped as she continually is being admitted and held involuntarily. Another section of the Canadian Charter of Rights that is breached is Section 12, Treatment or Punishment, which states everyone has the right not to be subjected to any cruel, or unusual treatment or punishment. The Empowerment Council finds that this new provision infringes Section 12 because psychotic treatment is not being forced in patients in the CTO programs. Section 15, which states every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. This section is also breached as Ms. Thompson is being involuntarily admitted and discriminated as an equal because of her mental disability. My questions are, do you believe that the court made a good decision when they dismissed the constitutional challenge to the expanded civil committal criteria and community treatment orders and to continue involuntarily admitting patients? And also, do you believe that the CTO program should force psychotic treatment on all patients living there? Thank you.